Hello everyone, this is your host Urvashi Chauhan. Welcome to Courts Today by Live Law, your one-step destination to all legal developments in the country. Let us start. Starting with an update on the matter relating to NEET UG 2024. The examination, as you know, is under the scanner for various reasons like the alleged paper leak, award of grace marks against the time loss and other irregularities or discrepancies that occurred during the conduct of the examination. In a petition filed by Xylem Learning Private Limited in relation to this case, the Supreme Court today sought response of the National Testing Agency on the time limit for raising the grievance regarding the OMR sheets. The petition, among others, raises concerns about the grant of OMR sheets to the students who appeared for the exam. Right at the outset of the proceeding, vacation bench of Justices Manoj Mishra and S.V.N. Bhatti said that the present writ petition had been filed at the instance of a coaching center and questioned as to which fundamental right of the coaching institute had been violated. Senior Advocate R. Basant stated that petitioners also included students who were supposed to be given the OMR sheets. He sought interim relief to obtain these sheets as some students had not yet received them. The NTA Counsel responded that the OMR sheets had been uploaded and distributed to candidates. The court then asked if there was a time limit for raising grievances about the OMR sheets. The NTA's counsel said that he would check, but Senior Advocate Basant argued that no defined procedure exists for raising objections. The court then issued a notice to the NTA and tagged the petition with similar pending petitions. The Karnataka CID today filed a charge sheet against former Chief Minister B.Y. Yediyurappa in connection with a POCSO case registered against him. Special Public Prosecutor Ashok Naik said the charge sheet had been filed before the Special POCSO Court. The charge sheet is filed under provisions of the POCSO Act and the Indian Penal Code against 4 accused, including Yediyurappa. As per the complaint filed by the mother of a 17-year-old girl, it was alleged that the accused sexually assaulted her daughter during a meeting in February at his residence in Bengaluru. In March, the police registered the case. Later, it was transferred to CID for further investigation, which re-registered the FIR. Recently, when Yediyurappa failed to participate in the investigation on a notice issued to him, the CID secured a non-bailable warrant against him. The same was challenged by Yediyurappa before the Karnataka High Court, which had stayed the warrant. The Karnataka High Court today orally observed that the fourth estate, which is the media, is the most important estate today. And if it was not for the media, those in power would conceal everything from the public. A single-judge bench of Justice M. Nagprasanna was dealing with a petition filed by Ajit Hanumak Kanavar, head of news and programs at Suvrana News Channel. He is booked under IPC for allegedly creating communal disharmony by using the Pakistani flag to represent the Muslim community of India in a show that aired on 9th May. Ajit sought quashing of the complaint on the ground that the depiction was due to oversight and that the same was rectified within an hour of the broadcast. A public apology was also issued on all social media platforms of the channel. His counsel contended that the allegation of creating a rift between two religions was absent in this case. The prosecution contended that Ajit was in the habit of broadcasting fake news and being a professional, he could not take the defense of oversight. When the public prosecutor added that these speeches caused a lot of nuisance and blamed the media for it, the bench disagreed, stating that the media was crucial for uncovering the truth and should not be dismissed. It emphasized that while misuse can occur, it does not mean the entire media is bad. Further, the court extended its previous order preventing any action against Ajit. It gave the special public prosecutor 2 weeks to file objections and maintained the protective order against harassment and coercive actions until the next hearing. The Sikkim High Court has condoned the delay in filing a criminal appeal which was caused due to the petitioners seeking services of a private counsel and being unable to secure the same within the requisite time. Justice Meenakshi Madan Rai was considering a criminal revision petition preferred by the petitioners in this case against the order of the Session Court, which rejected their application for condonation of 388 days delay in filing the appeal. The magistrate had actually convicted the petitioners for extortion and house lurking in the year 2022. The petitioners contended that they sought to engage a private counsel after their conviction, but they were unable to engage one on time as they were in jail, and only the wife of one of the petitioners was involved in looking for a counsel. Therefore, they prayed for condonation of delay. The court referred to the earlier judgments of the Supreme Court, where it was held that there needs to be a sufficient cause to condone the delay in filing appeals. The High Court opined that the expression sufficient cause must be interpreted liberally to condone delay in the interest of justice. The court was of the view that there were mitigating circumstances in favor of the appellants. It noted that the petitioners have a right to engage a private counsel if they are not satisfied with the services of a legal aid counsel. The court also noted that the petitioners did not exhibit gross negligence or deliberate inaction. It held that mere technicalities ought not to impede the path of justice, and therefore condoned the delay in filing the appeal. The National Consumer Disputes Redressal Commission has held that medical professional is not liable simply because an error in judgment if the chosen treatment was reasonable. In this case, the complainant's wife was admitted to Paras Hospital due to severe respiratory and cardiac issues. She suffered a cardiac arrest but was revived and placed on a ventilator. Despite her severe infection, a CRT-D device was implanted by the doctor. The request to transfer her to another hospital was denied and her condition worsened and she died shortly afterwards. The complainant claims that the pacemaker caused her death due to medical negligence and was overcharged for the procedure and the doctor's fees. The husband filed a complaint before the district forum seeking 13 lakhs in compensation. The district forum held the hospital liable for deficiency in service, directing them to pay 25,000 for compensation. Aggrieved by the district forum's order, the hospital appealed to the State Commission of Haryana, which was dismissed. Consequently, the hospital filed a revision petition before the National Commission. The National Commission has now observed that in medical negligence cases, it is not sufficient to blame a doctor for an unfortunate event without specific evidence of negligence. But the Commission found that although the pacemaker, a high-value item, was not shown to the complainant before implantation, which constituted a deficiency in service, there was no evidence of an ulterior motive or pre-existing infection in the device. The Commission allowed the petition and modified the District Commission's order, directing the hospital to pay 2 lakhs as compensation for the deficiency in service within 1 month. In another update, the Orissa High Court has ordered the state to pay 10 lakhs as compensation to parents of a minor boy who succumbed to injuries sustained after a toilet wall collapsed inside the school campus. The single bench of Justice Sanjeev Kumar Panigrahi observed that the collapse of the toilet building wall was due to sheer negligence on the part of the state, who are duty-bound to maintain the project upper primary school building and its surroundings in a proper manner. The court has ordered infrastructure safety audits in schools across all the districts in the state. The boy here, studying in class 2 in government-run Project Upper Primary School, was playing along with his friends inside the school premises when suddenly the damaged wall of a latrine collapsed and he got trapped under it. He was admitted to a nearby hospital, but he succumbed to his injuries. When the authorities denied compensation for the death of the student, his parents moved to the High Court. The court deemed it proper to direct the state authorities to pay a compensation of 8 lakhs to the petitioners, in addition to the ex gratia amount of 2 lakhs already declared by the authorities. The court further ordered for constitution of district education infrastructure safety audit committees in each district. The Madras High Court has dismissed a plea seeking to reduce the application fee for the All India Bar examination conducted by the Bar Council of India. The bench of Acting Chief Justice R. Madhavan and Justice G. R. Swaminathan was hearing a plea filed by an advocate who contended that the application fee had to be reduced. The court, however, was not inclined to grant relief. It observed that unlike the enrollment fee prescribed under the Advocates Act, there was no statutory provision relating to the examination fee for the All India Bar examination. The court noted that there was no legal right for which a mandamus could be issued. The court further noted that even in cases where there was no legal right, the court could interfere if it thinks that the quantum of the fee is exorbitant. In the present case, however, the court noted that the application fee was 3,500 rupees, which could not be called exorbitant. Let me tell you, in 2017, the Bar Council of India hiked the application fee for AIBE to 3,500 rupees. For persons belonging to scheduled caste and scheduled tribe category, the application fee is 2,500. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.